Hey, everybody. Welcome to Thursday night. Welcome to the Consumer Warrior YouTube channel. Appreciate everybody checking in today. Man, the week seems to go by quick. I know that once it's Thursday night, the week's almost over. So we're here and we're getting ready to start. Each and every Thursday night in the YouTube channel, I do this live question and answer where we talk about bankruptcy issues. We talk about debt collection lawsuit issues. We talk about all of the kind of things that you're dealing with related to pretty serious debt problems. So I appreciate you tuning in tonight. And for the first time too, I'm actually doing this via Facebook as well. I realized I can stream this directly to Facebook, so you can catch it here on YouTube, or you can check us out over at on the Facebook there as well. Each week I provide my weekly disclaimers that while I am a licensed attorney in the state of Arizona, I cannot provide legal advice. We've never met. I don't know the specifics of your case. And most importantly, I can't practice law outside the state of Arizona. So if you are outside the state of Arizona, you need legal advice, I highly, highly recommend you contact a bankruptcy attorney in your state who can help you out to give you specific legal advice. All right, let's jump into how we do this. So in the chat section over there, if you have a question, you can go ahead and put it up. If you're a big supporter of the channel, like Dave Lamb is, who's here each and every week, actually contributes to the channel. I appreciate that. But you can put your question there, and I will try to get to most of them. We usually go anywhere from 15 to 30 minutes each week, and I'm happy to address any questions. So you can go ahead and start putting them in there. I do like to start off with something that I've been thinking about recently. I want to do a quick bankruptcy thought. A lot of people, most people who file bankruptcy file Chapter 7 bankruptcy. And Chapter 7, you do have to qualify for it through what's called the means test. This is something back that they changed in the bankruptcy code back in 2005. I remember when I was in law school, I was taught by one of the preeminent bankruptcy scholars, Bruce Markell, the Honorable Bruce Markell. He was a bankruptcy judge, law professor, and he wrote really the book. He helped with drafting the bankruptcy code. He helped draft something called Collier's on Bankruptcy, which is the premier treatise on bankruptcy. And he was always talking about these amendments that were eventually going to take place. So they took place in 2005. And the biggest change is that you have to pass a means test to be able to qualify for Chapter 7. Chapter 7, how they do it, they look at the average, or they look at the total number of people in your home. And then there is an income limit based upon the number of people who live in your home, that as far as you being able to qualify. So for example, here in the state of Arizona, if you want to file Chapter 7 bankruptcy, you have to make less than $55,000 a year, give or take. And then it just goes up. So like for a family of 4, I looked up the specific numbers, $85,000 a year. And then for every member of your family that's higher, more than 4, it's $9,000 per month, or per year, added on top of that. So if you are over that, though, all is not lost. There are numerous deductions you can make: taxes, car payments, house payments, some medical bills, those kinds of things. So I wanted to throw that out there so that you can understand kind of if you're needing to file for bankruptcy, you need to look at your income, the number of people who live there. It's actually something that changes fairly frequently. They change it on at least a quarterly basis. I'm going to put a link in the chat that is going to give you, if you want to check it out. This is from the United States Trustees Office. They have a table. They update this pretty frequently, but this is the most recent data. It'll show you your state and then the amounts that you have to make to be able to qualify for that. So, Marcos, you're one of the true regulars here. I appreciate it, and thank you for supporting the channel today. So, all righty, let's jump into some questions. Looks like we have a bankruptcy question here by Kevin Mitchell. Kevin is wanting to know, does mortgage forbearance affect bankruptcy? I guess I probably need a little bit more information as far as what do you mean, does it affect it? Let me just kind of tell you how in general mortgages are dealt with in bankruptcy. If you file a Chapter 7 bankruptcy, the mortgage is really not impacted, as far as you still have to keep making the payments if you want to keep the house. I once had a client a long time ago who complained to me saying, hey, I didn't share with her that she had to keep making the payments on her house. She thought that debt was discharged. We worked it all out, but it makes sense. There's no free house in bankruptcy. So you have to continue to make the payments on it because it's a secured debt. There's not only the debt, but there's the actual, there's the deed of trust, there's the lien that attaches to the house. And so if you want to keep your house, you have to continue to make the payments on it. Now, Chapter 13 is a whole different ball of wax with a mortgage, particularly if you find yourself behind on the mortgage. If you're behind on the mortgage at Chapter 13, which is really one of the reasons it's there, is to help you get caught up. If you're facing foreclosure and you're worried your house is going to get foreclosed on, or there's a date that they're going to sell it, it's imminent, you can file a Chapter 13 bankruptcy, stop the foreclosure, and then propose a plan on how you're going to get the past due payments caught up. And you have usually up to 60 months, so up to 5 full years to get that caught up, which can be a big relief for a lot of people. The key to success in a Chapter 13, though, is you have to start making the regular monthly payment as it comes due. Otherwise, the whole thing's going to fall apart. And in Arizona, if you're behind on it, you actually have to do what's called a conduit Chapter 13 plan, where you have to make your plan payment through the bankruptcy court or through the bankruptcy trustee to be able to do that. If you have a forbearance, the only way that would impact things is probably more in a Chapter 13 scenario. If you're not required to make any payments right now, the forbearance may change your disposable income calculation, which is really kind of getting into the weeds of it, in that it could increase the amount of disposable income. But overall, the forbearance shouldn't impact it. I don't even want to go there. So it's let's see if Kevin, more specifically, you're wondering if it's better to wait until the forbearance is over to filing Chapter 7. It won't matter. In my opinion, it won't matter. The forbearance is not going to really do anything as far as the payments go. If you're intending to stay in the house, you might want to look at different loan modification options, something like that. Or if they're just part of the forbearance, they're just tacking this on the back end. It's not going to make a big difference either way when it comes to Chapter 7 filing the forbearance. Because it's a secured debt, you're still going to owe it on the other side of a Chapter 7. It's just really how they deal with it in the meantime. So, all right, let's see what Bobby has for us tonight. What happens if 20 creditors sue and they get a judgment on you and they freeze your accounts, but you have no income, no assets, no money in the bank due to neuropathic pain for which SSDI is denied? So SSDI being Social Security disability. That's a tough spot. It sounds like in this scenario that you may be judgment proof. Now, judgment proof is where we're saying that even if a creditor gets a judgment, there's not a whole lot they can do to you. They can be annoying and they can kind of harass you, but they can't do much else to you. So because you got to think like a creditor. Think like that. What the creditor wants to do is get the judgment so they can garnish your wages, go after bank accounts, maybe lien property, seize assets. And if none of those are available, then there's not, they have a piece of paper, but there's not much else they can do. The thing that I always say, because I actually did a video on this, I think I called it the do nothing strategy to winning your debt collection lawsuit. Very rarely do I recommend you take this approach because even though you may be judgment proof now, you might not be in 10 years. And unfortunately, the trend with almost every state is judgments are good for 10 years and they can be renewed for 10 years, and it just goes on and on and on. So if it's something where hey, the situation is not going to change, I'm not going to have assets in the future, I'm not going to be employed in the future, then that's one thing. In those situations, even then, I like to try to reach out to the creditor and see if something can be negotiated where it would some kind of lowball settlement offer. Because you could provide that information of saying, look, I'm disabled, I don't have income, I don't have assets. They likely have a lot of that information, and they may take a really low dollar amount to just get the whole thing to go away. So that's one approach. If with that, I can tell you with Social Security disability, it's almost always denied the first go round, the first application of it. I don't practice that area, but I have an attorney here in my firm who does, and they often have to appeal that and submit it again. And so if you do appeal that and you get on Social Security disability, those funds are exempt under federal law. And so even if they had a judgment, they wouldn't be able to take it. They could try to freeze the account, but you could raise an objection and they would have to let those things go. So hopefully that helps. Sorry about the situation is tough, but it may be something where, like I said, they may be willing to take kind of a smaller dollar amount just to get the whole thing taken care of. So, and that actually kind of leads to another topic that I've been dealing with lately is the wage garnishment, the freezing of the accounts. Like I said, what they want to do, they want to get the judgment and they want to serve the judgment or the writ to get a garnishment order on the bank accounts and freeze those funds. This is going to be Arizona specific, but states generally tend to be the same. But what the garnishment does, because I think understanding the mechanics of this, particularly with bank account or wages, can help you as far as negotiating settlements. They serve the garnishment order on your bank or on your employer. The employer starts withholding the funds. The bank will freeze the account, like Bobby says here. But that typically doesn't mean that the money is automatically just transferred. It's usually frozen in the account. You have an opportunity to object or raise any issues. For instance, if the money's exempt, if the money is Social Security, it can be, you can raise an objection to it. It's only if you just ignore it and don't raise an objection that eventually the court will send an order over to transfer that money. So that was a little bit of a misunderstanding. I've talked to some people that were saying, they thought as soon as the bank account got hit that money was just, a check was sent over to the debt buyer or whatever, and that's not the case. All righty. Mitch, thank you. Thank you for the, man, you guys are generous today. I appreciate that. Let's see what Chandra has to say. Chandra. I don't want to mess it up. I had my pretrial hearing. No settlement was reached. Now we go to trial. What do I do? I can tell you if it's a debt buyer case, one thing you got to look for is if they filed a motion for summary judgment. That's a favorite of the debt buyers, is they're going to come and hit you with a motion for summary judgment, because what that does, if they prevail on that motion, there is no trial. Trial goes away. With debt collection firms, most of them have relatively few lawyers that work there for the number of cases that they're handling. They work in gigantic volume. In Maricopa County, where I work in the Phoenix metro area, the debt collectors file anywhere between 5,000 and 10,000 new lawsuits each and every single month. And there's like 3 firms that handle it, and a total of probably like 10 to 15 attorneys, which is, most attorneys have caseloads of about 30 to 70 cases, that kind of thing. These guys have thousands. And so because of that, they want to file a motion for summary judgment. You say, Chandra, you said you're there in Arizona. Because of that, they will file a motion for summary judgment because they can't do trials in each of these cases. And so if you get hit with a motion for summary judgment, they also know that that's one of the more difficult things to respond to. It's not like the complaint. It's not like where you can just file an answer or kind of admit or deny. You actually have to go through and pick it apart. I have an online tutorial that I have on these things. If you look at the top of the chat here, I actually, where did I put it? I put a little link to it. This is my shameless plug for my online tutorials. But you can click on that. There's one that's specifically geared towards how to respond to a motion for summary judgment. By far and away, that's the most difficult response. And if you don't have an attorney and doing it on your own, it's tough. It's tough to do that without kind of having some idea. But that can be a good tutorial. So, and going back to your question, they'll probably hit you with the motion for summary judgment. They asked for 90 days to reschedule. Sorry, this is an ongoing question here. Ongoing question. So the reason why they might be doing that, some of their strategy on this might be, they might be asking for it to be at least 90 days out, because under the Arizona Rules of Civil Procedure, in Justice Court, they can't file a motion for summary judgment if trial is less than 90 days away. So they may be saying, hey, Judge, just put it at least 90 days out so they can come in and file that motion for summary judgment. If they do, you have to respond to it. You got 30 days to respond to it in the state of Arizona. Now, if they don't, if it's going to go to trial, that's when you need to get ready. I mean, and in getting ready for trial, one nice thing, if there is a nice thing about going to trial, but being on the defense, you're defending this, is it's the plaintiff who has to prove everything. It's not you. You don't have to come in and disprove all of the elements of their case. They have to come in, prove that you had the debt, prove the debt was transferred, prove that the dollar amount, show that your specific account was included in that transfer. If they can't do that, they're not going to be able to establish their case. So Again, shameless plug. I have a tutorial on how to get ready for trial. And so that could be helpful. I also have a ton of videos here on doing things like cross-examination, little things like I'll always remember, excuse me, when I first became an attorney, you go to law school for 3 years, take the bar, all this kind of stuff. And the first time you walk into a courtroom on your own, the first thing every attorney says is, which table do I sit at? You're like, there's 2 tables there for the attorneys. And I'm like, I don't know which side of the room to sit on. I don't want to look like an idiot. The plaintiff usually sits closest to the jury box. If there's a jury box, a lot of smaller courts will even have little name tags, plaintiff, defendant. But that's how you always know, is that the plaintiff always sits near the jury box. So so I know that it's hard for me to go over and everything like that, but that's what the next steps, Chandra, are likely going to be, is it's going to be a motion for summary judgment, or they'll just push it right to trial. So, all right. See what Mitch listened to all of my YouTube videos, and I answer all the questions live last week. Take the fear and guesswork out of these cases. I appreciate that comment. That's why I started doing this. And actually, kind of the history of my law practice, I started blogging about these things quite a while ago to provide, I mean, granted, it helps my law practice, but it also just provides information. I started writing, I had a blog and I wrote about debt buyers, and I focused on Midland funding. And it got to the point where I was #1 in the world. If you search for Midland funding, I'm not anymore, but I was for quite a while. And I even got their mail, and people would always call me and say, why are you suing me? And I'm like, I'm not suing you. I'm the good guy here. I'm trying to help you. Yeah, I appreciate the kind words. I'm glad that things are helpful here. So, all right. Looks like Brian's going to jump into some things too. If they ask for 90 days to schedule, file a motion to answer to the judge, tell them you'd like this to proceed quickly. And you know what, Brian brings up a great point, that if just because they're asking for it, I mean, you can object to it. If they're saying, hey, I want 90 days, you can say, you know what, I'm tired of this. I want this over. And I can tell you the judge wants it over too. And very rarely, unless their schedule can't accommodate it, they want to get these things done. There's courts here in Arizona where they set the trial date as soon as you file your answer, just because they want to move these cases. In the state of Arizona, in justice court cases that deal with matters under $10,000, there's by rule, they have 10 months to get this case resolved. Otherwise, they're supposed to dismiss it. So they want to keep this thing moving along as quickly as they can. So a couple little bits here, Brian, because these are good. It says, haven't proved the debt through contract. If they have affidavits, tell the judge affidavits cannot be cross-examined, and request live witnesses. Always live witnesses. Affidavits are hearsay. I learned this the hard way as a young lawyer, that I had someone in court on the stand. This was in a real estate case. This was even in a jury trial. So the whole shebang. And I was trying to introduce an affidavit of the person who was sitting in court, and the other side objected to hearsay, and the judge sustained it. And at first I was just like, I'm not grasping this. That affidavit was an out-of-court statement. If you can't cross-examine an affidavit. They should not be able to submit that and have those statements lie there unopposed. At trial, you have an opportunity to oppose that. So you should definitely do that. So, all right, let's do a couple more. L. Anderson, can you have 2 bankruptcy cases active at the same time? It's possible. I don't think you need to do that. And maybe the question is, I've seen people who have like a Chapter 7, and then maybe they file a Chapter 13. Back in the last recession, we called that the Chapter 20, the 7 and the 13 added together. You could, if the discharge hasn't been entered in your Chapter 7, you wouldn't want to file a Chapter 13. And let me tell you the scenario where this would play out is we would see people who would file Chapter 7. They would get the discharge and eliminate all of their credit cards, medical bills, all that. But then at the same point, they were behind on their mortgage payments, HOA payments, car payments, something like that. And then after the Chapter 7 was discharged, they would file a new Chapter 13, which they could then pay out their arrearage on the house and that, because you weren't trying to get you're not eligible for a discharge in the Chapter 13 because you just got one in the Chapter 7. But you don't need a discharge. You really just need the kind of the framework of a Chapter 13 to pay things back. They changed the rules to kind of eliminate some of that, in that the automatic stay, which stops creditors from being able to collect against you. If you've had a case pending in the year prior, it's only good for 1 month unless you go into the court and prove why it should be longer. That's way too into the weeds probably of things. But it is what it is. All right. Let's see what Belinda has to say. Belinda, can I make large purchases immediately after filing bankruptcy, such as buying a car, or do I have to wait until my debt is discharged? You are permitted. I've had clients who they will have cars that they either can't afford or they have a bad contract on or something. They'll go into bankruptcy with those cars. They'll surrender the cars through the bankruptcy, and they will then go and buy a new car before the case is over. I generally tell people it's better to wait until the meeting of creditors is complete. That's usually about 4 to 5 weeks after the case is filed, just kind of keep everything status quo at that point. But I would usually something like that is fine. The problem that you're going to have is if you're going to pay cash, like, so if you were planning on buying a car and you had, 10 grand saved away in the safe or under the mattress or something, and then you want to go and pay that, you can't do that because you can't go into bankruptcy with a lot of cash. It's actually in Arizona, it's really minimal. It's about $300 to $600 on the day of filing. So if you're going to go and finance it, you could do that. And I can tell you that there's car lenders who do not have a problem with the fact that you're either just recently out of Chapter 7 or even that you're in Chapter 7. And something that surprises almost every client I have is as soon as we file their bankruptcy case, their mailbox is full of credit card ads and car ads every single day, because the lenders view you as a good risk for 2 reasons. One, they're anticipating you're getting this discharge, so your debt's going to go away and you're going to have more disposable income. And 2, you can't file Chapter 7 again for 8 years. So you're a good credit risk for them. All righty. Let's see. We'll see what Rick. My question is, what if I received $3,000 of cash for my birthday and invested in crypto? Can she grab half of it? I think I'm missing part of the question here, Rick. If you can clarify that, maybe I can address that. Sorry, I clicked too quickly without seeing if there was something up above that I might have missed. Let's jump in this one. What not to do before bankruptcy filing. I have a great video on the YouTube channel about this where I go into detail. The things you do not want to do, there's 2 big ones. Every time I do a consultation, I ask people if they've done these things. One is if you transferred your assets out of your name at any time in the last 2 years, particularly if you just gave something away. You do not want to take your name off a vehicle, transfer your boat into your brother's name. You don't want to do any of that. If you sold something legitimately, if you sold it, if you had a car and you put it on Craigslist and sold it for 10 grand and that's roughly what it was worth, that's fine. The problem you run into is if prior to bankruptcy, in the 2 years prior to the filing of your case, you transferred something for less than what it was worth. So if you have a car and you're selling it, the car's worth 15 grand and you sell it to your brother for $500, it's not going to fly. The court's going to go and it's deemed a fraudulent transfer. Even if that wasn't your intent, if you were doing it innocently, I can tell you where it comes up all the time is families where their teenage kids, they get a car when they're 16. They're not old enough to have the car in their name. And so it's in mom and dad's name. This just recently happened in my home. My 17-year-old daughter, she saved up. She's been working. She bought a car, $4,000 car. She bought it, but it's in my wife's name because my daughter's not old enough to have the car in her name yet. And so then what happens is kids then go off to college. They're 20 years old. Mom and dad need to file bankruptcy. And then when they start to fill this out, they're like, oh, we have to disclose assets. That's in our name. It's not our car. I'm just going to transfer it over to my kid. That can cause problems if it's done within that 2-year window prior to bankruptcy. There's ways around it. It's not there's ways that we can, or it doesn't cause a problem, but it's definitely something to be careful of and not do that. Don't transfer things out of your name. right prior to filing bankruptcy. The other one is paying back loans to family members or friends in the 12 months prior to filing bankruptcy. That's known as a preferential transfer. So if I owe my brother, $5,000 that he loaned me to buy that boat that I'm trying to transfer to him, and I've been making, $250 a month payments to him for the last year, that can cause a problem. The bankruptcy trustee who's assigned to your case can actually go back and get those funds, and bring them back into the bankruptcy case. The way they do that is they go and they sue your brother, get all that money back. It makes Thanksgiving awkward, all that kind of stuff. So those are important things to know, not to do prior to filing bankruptcy. If those are the issues, for sure, bring them up to your attorney, because a lot of times there's kind of workarounds that you can do, or there's settlements that can be made with the trustee, or sometimes you just wait to file your case. But definitely bring those up. There's nothing worse for a bankruptcy lawyer than to be sitting in a meeting of creditors with the trustee and hear your client say for the first time, by the way, I did this. So there you go. Let's go back to Rick's question. In a divorce in California, any gifts are considered separate property. If I receive $3,000 cash for my birthday and invest in crypto, can she get 50%? That's worth more than $3,000 today. Rick, I don't want to speak out. What do they say? I got to stay in my lane. You're going to need to talk to one. It's going to be California specific. Arizona is a community property state as well, but excuse me. I would recommend you talk to a family law attorney in the state of California, because that's going to be very specific to state law there, as well as just the family court in general, which I don't delve in at all. So, all right, that will do it for tonight. I appreciate everybody checking in. Appreciate all those who continue to support the channel, who are here each and every week, who financially support the channel. It does help as we do that. Again, if you're in the state of Arizona and you need legal assistance, always feel free to reach out to my law office. I work at a law firm called Jackson White. ConsumerWarrior.com will take you to our webpage. I'm happy to do consultations. I can only do it for the people who are in the state of Arizona. Every now and again, people from other states try to sneak in there. I know who you are. But unfortunately, I can only do consults for people in the state of Arizona. And then also, if you're not in the state of Arizona, I do have these online tutorials that have templates and forms and stuff like that. And it's instruction from me on kind of how the whole process plays out. But I hope that is helpful for tonight. Again, appreciate y'all checking in, and